Have you ever wondered what happens behind closed doors with plea negotiations between the defense attorney and the prosecutor? This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. Yes, actually, I have always wondered about that. What really goes on in these plea negotiations? Like, what's the first step of this process?
Well, the first step of the process is, once the prosecutor has given the defense attorney the evidence that they intend to use against the client, and the defense attorney has thoroughly reviewed it, the court often gives the parties deadlines and sets hearings to let the court know the status of the case. So as these deadlines approach, the prosecutor will generally make an initial offer to the defense attorney.
Okay, and I'm going to guess that this initial offer is not always ideal for the defendant. Is that safe to say?
Well, I would say, 7 out of 10 times, probably it's not the best deal that you're going to get. Every now and then a prosecutor surprises you and gives you an amazing offer you just can't resist. But yes, initially that first offer is just a starting place, and the defense attorney obviously communicates that offer with the client, and then if the client isn't happy, or if the attorney doesn't advise that they take that plea offer, then the attorney and the client discuss maybe a counter offer. And so the defense attorney comes back with something more of what would be an ideal outcome for the client. And, so it's like you start high, the prosecutor starts high, and the defense attorney starts low. Which is typical in a lot of negotiations. And it really depends on who is holding the most cards or has the best leverage as to which end of the spectrum the deal actually lands.
Well, do you have an example of where the prosecution put out a first offer that you found was not ideal at all for your client, and then just describe what that offer was and how it developed from there?
Sure. So, a lot of times the cases that are most negotiated in our office are the ones where there's an allegation of sexual assault. Because, the sexual assault case for the prosecutor is really one of the more serious cases that the office handles. And so a lot of times on those type of cases, their first offer involves significant prison time and, pleading guilty to the offense as charged. So a particular example that I'm thinking of recently involved a sexual assault case, which, the sexual assault cases are always the more serious cases for the prosecutor and obviously for the client charged with them. And right out of the gate, the prosecutor made the offer that my client plead guilty to one of the 2 counts, and that he would, in exchange for the guilty plea, he would dismiss the second count, and then he was going to recommend a significant prison sentence for my client. Now, in this particular case, it's just the 2 of them, he said, she said, and it really would come down to the credibility of the 2 people that were in the room. And so, both of them were drinking, and the prosecutor had some serious issues with their case as well. So we rejected that offer, and we set the case for trial.
What amount of years was he saying he would possibly get, this defendant of yours?
Sure, he was asking for a 10-year sentence, and so it was again a serious allegation, and so it was really a life-altering offer. If my client took that offer, that's a lot of time to spend in prison, plus he'd then be a registered sex offender.
Okay, so that must have been really difficult for your client to hear, even, that other charges would be dismissed. So what did you come back with?
Well, we came back with, no, we're not going to take that offer, and let's just go to trial. Well, then the prosecutor pulled one of the tricks out of their hat that they often do, and informed us that the victim had disclosed, some additional conduct which would result in an even more serious offense. And so the prosecutor threatened to stack on an additional charge. And, this was really, really intimidating to my client, because if the jury believed the alleged victim, he was looking at a very significant amount of time in prison if he was convicted.
Okay, so how did this story unfold?
Well, the alleged victim made the disclosure in counseling to the counselor. And then this information was shared with the lead investigator, and the lead investigator told the prosecutor about the disclosure. And so, again, we made the offer to the client. The client was really scared and was actually considering taking the original offer because he didn't want to face an additional charge. But, I pushed back on that, and I asked the prosecutor for the specifics. That is, all he said was there was this additional allegation made, and I'm looking at charging it as well. Well, when I asked for more information, he told me it was disclosed to the alleged victim's counselor, and the counselor shared it with law enforcement, and he was going to have law enforcement write a report. And he said that would be great. We would love, more specifics before we take this plea deal based on, a new charge. And come to find out, when he cleared it up with his investigator, the nature of the allegation did not fit a more serious charge. In fact, it was a little shady, because that the additional allegation came after my client rejected the first offer, and it was almost potentially as if the victim was acting retaliatory. And so the prosecutor saw how I would use this against her if we went to trial, this additional allegation that was late, in the game disclosed. And so the prosecutor said, okay, well, never mind. Now that I know more about this, I'm not going to charge that. And so then we were back into negotiations.
Wow. Well, did it turn out well for your client in the end?
Yes, I said, if this was the plea deal with this looming more serious charge over my client's head, then we need a better offer, an offer that, involves significantly less consequences. And so we ended up getting an offer that involved probation. And, from where we were at a 10-year recommendation for prison down to probation, it is definitely an offer that the client considered. And whether or not he takes it is still up in the air, but we at least have a really good option for him if he decides he doesn't want to risk going to trial.
Well, that is a phenomenal story. It sounds like it's already in so much better shape than it originally was. And of course, all of this only possible by having a very, very skilled criminal defense lawyer at the helm. So how might someone get in touch with you for this same type of service?
Sure, we'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.